The Trump-Netanyahu peace for Gaza does not conform to international law and does not augur well for sustainable regional and international peace and reconciliation. The Trump-Netanyahu construct is incompatible with the UN Charter and with the erga omnes obligation of all UN member states to ensure the enforcement of Security Council resolutions, including Resolution 242 of November 22, 1967, which ordered the withdrawal of Israeli forces from occupied Palestine territory. The only hope for durable peace in the Middle East lies in the implementation of the concrete, pragmatic advisory opinions of the International Court of Justice of July 9, 2004, July 19, 2024, and October 22, 2025. The implementation of the final report of the UN Independent Commission of Inquiry submitted to the Human Rights Council on September 16, 2025, and the implementation of the detailed reports of UN Special Rapporteurs on Palestine, John Dugard, Richard Falk, Michael Link, and Francesca Albanese. There cannot be a separate peace settlement for the Middle East that ignores binding United Nations pronouncements. It would not only be illegal, but it would be illegitimate. A fait accompli does not create international law. It only manifests the lack of effective enforcement mechanisms in the United Nations system. Accepting the Trump-Netanyahu dictate would entail abandoning the whole body of international law and the international order established at the end of the Second World War. It would mean venturing on the slippery road to World War III. The United Nations bears particular responsibility for what happens in the Middle East, because it was the midwife that facilitated the emergence of a new state called Israel and failed to ensure the emergence of a second state called Palestine. The UN could have done it if the right impulse had come from the great powers. It could have been possible in the early years, before the many wars and the growing hostility between Muslims and Jews. But what is the United Nations but its member states with all their competing values, conflicting interests, and endemic contradictions? Over the past 80 years, there have not been great visionaries or leaders. All have watched the ethnic cleansing of the Palestinians and the ongoing genocide in Gaza without adopting concrete measures to prevent the genocide and punish the perpetrators. Admittedly, some academics did anticipate and condemn the crimes, and there have been dozens of General Assembly and Security Council resolutions, but in the absence of enforcement of international law, genocide has become the new normal. In many ways, the United Nations is responsible for the existence of the State of Israel, which emerged from a Zionist project that was already anachronistic when conceived, and which is fundamentally at odds with the purposes and principles of the United Nations. Although rooted in the Jewish experience of persecution in Europe and Jews' historical attachment to the Holy Land, the Zionist experiment belongs in the imperialist and colonial mentality of the end of the 19th century, and the idea that Europeans could settle in other parts of the world and displace the local populations. This latter mindset is responsible for endless wars of decolonization in Africa and Asia, and for the unending saga of the Palestinian tragedy. The establishment of the State of Israel, an apartheid state for Jews, where other ethnic groups did not enjoy the same rights, was only possible because of the enormity of the Holocaust and the solidarity that the world felt for the Jewish survivors. Solidarity and empathy were legitimate, but should not have been implemented at the expense of the native Palestinians. The irony of history is that the State of Israel, which emerged from the Holocaust, would soon become a practitioner of ethnic cleansing and genocide, that the horror that Jews endured during the Second World War would be visited upon the Palestinians, who had no responsibility for the Nazi crimes. On May 11, 1949, by virtue of Resolution 273-3, the General Assembly accepted Israel to membership, noting that Israel is a peace-loving state and is able and willing to carry out the obligations contained in the Charter. Since the United Nations legitimized Israel's existence, it also has a special responsibility to monitor what happens to the native populations of the former British Mandate. In a way, it is anomalous for the General Assembly to have granted recognition to Israel, notwithstanding the Nakba of Palestinians since 1946. Notwithstanding the countless terrorist acts committed by Zionist organizations against Palestinians and against the British mandate holders, the blowing up of the King David Hotel, the assassination of UN envoy Foka Bernadotte in 1948, etc. Nevertheless, we should not forget that GA Res 273.3 implicitly conditioned Israel's UN membership on the declaration made by Israel that it unreservedly accepts the obligations of the United Nations Charter and undertakes to honor them. Indeed, the adoption of the resolution was preceded by negotiations with Israeli diplomats, in the course of which a number of conditions for membership were discussed, conditions that have not been met, particularly with regard to Israel's frontiers, which have been brazenly violated by Israel through its constant aggressions against and land grabbing from Lebanon, Syria, and Palestine itself. The international community knows from experience over the past 80 years, Israel has waged war on all of its neighbors and thus has demonstrated in practice that it is not a peace-loving state. It has engaged in countless aggressions against Lebanon, Jordan, Syria, and Egypt, thereby violating the principles and purposes of the UN Charter. This open rebellion against the UN Charter and international law would justify the expulsion of Israel from membership, as envisaged in Article 6 of the Charter, which stipulates, "A member of the United Nations who has persistently violated the principles contained in the present Charter may be expelled from the organization by the General Assembly upon the recommendation of the Security Council." Here lies the problem of UN inefficacy, the structural inability to enforce its decisions, because of the frequent abuse of the veto power by the permanent members of the Security Council. We observe that the Security Council does not always act within its terms of reference laid down in Article 24 of the Charter, and allows the 5 permanent members to act contrary to the purposes of the organization, which are to promote peace, development, and human rights. The abuse of the veto power, contained in Article 27, Paragraph 3 of the Charter, sabotages the potential of the United Nations and allows war crimes, crimes against humanity, and genocide to go unpunished. The egregious dysfunction of the system results from the bad faith of certain members who consider themselves as legibus salutis, that is, above the Charter and above international law. It is a disgrace that a state like the United States can abuse the veto power to shield Israel from accountability, to veto resolutions calling for a ceasefire, and to veto resolutions providing for the recognition of Palestine as a member state of the organization. Under normal circumstances, the Security Council would be expected to ensure the implementation of the advisory opinions of the International Court of Justice, but the United States blocks enforcement action against Israel and thus becomes complicit in the genocide. This has had a detrimental impact on the credibility of the organization. At the very least, a total arms embargo should have been imposed against Israel, sanctions under Chapter 7 should have been put in place, as well as monitoring mechanisms. All of this has been frustrated by the United States. On August 22, 2025, the United Nations declared a state of famine in Gaza. This was overdue because thousands of children and elderly had already died not only from bombs and bullets, but also from malnutrition and the lack of medical assistance and equipment.